To continue, I wanted to make sure everybody understood what I had did over the prior 2 years in sending notices and questioning concerning the property taxes. This was attached, what I'm about to read, to the original petition which I brought over on September 19th. This was the first letter I sent to the county administrator of Broward County, Bertha Henry, on November 20th, 2014. And I sent this out registered mail. Registered mail RA 75792053 US. And what happened, I didn't get a response, and then I further faxed it when I didn't hear anything on December 9th, 2014. So I want to read this letter to you so you understand basically how I'm presenting this case for them to review. So it reads, Dear Bertha, greetings, and I hope this finds you well. As County Administrator of the County of Broward, overseeing the entire county financial structure, having knowledge of said duties and obligations to the public, it would seem reasonable to presume that you can address the following with regard to property taxes and the county's authority to mail out a property tax bill. I recently received what appears to be a property tax bill, and I would like clarification on the legal authority for this claim or presentment under your authority. Are property taxes permitted to be assessed under the United States law? It appears this bill may not be consistent with the Constitution and statutes. For example, 31 USC 3124 exemption from taxation in part, and I go on to quote it. If 18 USC 8, and I go on to define obligations and other securities of the United States are as obligations or other securities of the United States, then it would appear that the use of a millage rate multiplied by the assessed value based upon Federal Reserve notes or an obligation of the United States would not be consistent with the intent of the congressional authority and thus be null and void on the face under 31 USC 3124. For even further clarification, per United States Treasury website, and I give that Federal Reserve notes, which I had gone over before, Federal Reserve notes are not redeemable in gold, silver, or any other commodity, and I quote all this stuff. In essence, it appears that the millage rate multiplied by assessed value or valueless Federal Reserve notes, which are required to be used to discharge the matter, would amount to zero or nothing. The county may rely on Florida Statute 192.011, Florida Statute 192.032, giving it authority to assess and ultimately collect property taxes. This Florida statute appears to be contrary to the Supreme Court case in Memphis Bank and Garner, Memphis Bank versus Garner, and contrary to 31 USC 3124, formerly 31 USC 742. If this is the case, then the Florida legislature is in violation of having abused their authority by having passed a statute that is in fact contrary to the law of the land. And then I go on to go into all that Memphis Bank versus Gardner. I won't read it now, but you may wish to look that up. I go on to say another question I would like to ask is with regard to the United States Constitution under Article 1, Section 10. No state, ... make anything but gold and silver in payment of debts. Since there does not appear to be any constitutional amendment with regard to method of payment, other than gold and silver, and for a moment it can be presumed that property tax is permissible under federal law, how can one pay a property tax bill? I am under the impression that the law does not permit impossibilities. If the county requires to be paid in legal tender or Federal Reserve notes, which by definition are obligations or debt of the United States, this could suggest that in fact the person paying this offer or presentment is actually increasing the national debt. If this is the case, would this not be a form of conscription of citizens, residents as the source of that credit for the nation into some sort of forced contractual obligation, even though the legal tender is already backed by their goods and services as outlined above by the Treasury Department? It would appear that the county is actually forcing the residents to war against the United States, almost like enemies of the state, by increasing the national debt through mandatory usage of private credit, usage of private internal script, referred to as Federal Reserve notes, which are by definition obligations of the United States. It would seem that there may be possible fraud and felonies existing under U.S. code. Since this may be the case, this now extends into numerous other violations under the U.S. code, such as mail fraud by using the mail system for illegal tax notices, unlawful conversion, attempting to embezzle funds of the U.S., etc. I hope I have this above scenario incorrect, and that your thoughtful and accurate response in writing within 10 days, signed with the wedding signature, will provide a legal and lawful insight to any possible misunderstanding or error on my part. If there is an error on my part, I would ask that you forgive me. My intention is well-meaning. As an alternative, and keeping in with the spirit of attempting to help my brothers and sisters out when possible, I believe under your statutes 12 USC 95A, 12 USC 95B, 12 USC 411, and 12 USC 342, that the matter can be settled in order to provide you with what you need. My only goal is to help provide the beneficiary, the United States, with a signature by accommodation to effect transfer of benefits to said beneficiary, the United States. Then I quote 12 USC 95A. To sum up, please either accept the bill of exchange, discharge the matter, then provide a paid in full receipt to the address above. Then this matter is closed. Or 2, notify me if you find a defect in this instrument, and I can help you remedy the defect so that we may help the beneficiary, the United States. Or 3, reject the bill of exchange outright by stamping not acceptable or dishonored. And then please provide a response to the above concerns as I have outlined above with regard to the United States Constitution, 31 USC 3124, and case law Memphis Bank and Gardner within 10 business days, signed with wet ink signature. I am sending this correspondence to you, a fiduciary or public trustee of the County of Broward, in good faith, in pursuance of and in reliance of 12 U.S.C. 95A, 63C, American Jurisprudence 2D, sections 241 through 250, and 5 CFR 2635.101. I suggest you look up those. Those has to do with public official duties and obligations. Continuing, in gratitude to the United States in exchange for safe harbor and hospitality, I come to you in peace in support of the United States, the beneficiary of the estate of Anthony Rubio. My goal is not to back anyone in a corner or get anyone upset. I'm not trying to get away with something. My ultimate ambition is to help save a bankrupt corporation called the United States before it is too late. If you can agree with this endeavor, please act upon 1, accept, discharge, or close the matter, or 2, counter or notify what more I can do for you so we can help the beneficiary, or 3, reject and provide a response signed with wet ink signature to clarify any error I may have with regard to Constitution, statute, and Supreme Court case. A response in writing is required within 10 business days. And then I had attached the bill of exchange, the County of Broward leadership philosophy, which is a contract to the public. I had put the county administrator's duty and definitions, which is a public contract. I put a copy of 31 USC 3124, a copy of 18 USC 8, a copy of the U.S. Department of Treasury Resource Center, a copy of the Memphis Bank and Gardner, the 12 USC 95A, the 12 USC 95B, the 12 USC 342, and 12 USC 411. So this is what I got back from Sharon V. Thorsen, Thorsen, and the title is Senior Assistant County Attorney. And it is dated December 11, 2014, and they have a file number 14-102-00. And it's addressed to Mr. Anthony Rubio. Dear Mr. Rubio, your letter to the county administrator questioning the legality of Broward County's levy of ad valorem taxes has been referred to me for a response. The authority of the county to levy ad valorem taxes is authorized by Article 7, Section 9 of the Florida Constitution and the county acts pursuant to such authority. Florida statutes provide for the method of collection of ad valorem taxes. The procedures for the collection and the consequences of non-payment of ad valorem taxes may be found in Chapter 197 Florida Statutes. Very truly yours, Sharon V. Thorsen, Senior Assistant County Attorney. So what I did was I decided to do a notice of default acceptance of dishonor, and I had that notarized. Needless to say, that wasn't a response to what I sent, but it is what it is. And I'm sorry for not looking at the camera. I'm just trying to make sure I get a little, it's a lot of papers here. Anyway, so what I did was I took care of the taxes, not a problem. I was a good, trustee de Santor. So last year I decided to write Lori Parrish, property appraiser for Broward County, and I made it simple. The letter is dated to September 1st, 2015. It's certified mail, I sent it. And it says, Dear Private and Confidential Communication. Dear Lori, it was a one-pager. I write to you, the woman who I believe at times acts in a public capacity as property appraiser for the County of Broward. I, a private man called Anthony and an authorized and exclusive user of the public person, a factitious entity, Anthony Rubio, accept your oath of office, bind you to that oath of office to carry out the following order. As I require of you to answer, respond, act upon the following as it relates to your duty under the title Property Appraiser. Number 1, does not 31 USC 3124 exemption from taxation provide an exemption in the computation of a property tax assessment? If the property appraisers uses sales figures, market value, or value based upon presumptive use of Federal Reserve notes, how is it possible that you, as the property appraiser, computes and or assesses a property tax with debt obligations of the United States, 18 USC 8, 12 USC 411? Please note, I do not dispute the fact that there is a statutory authority for the actual property assessment. The question being addressed to you as property tax assessor or appraiser assessing a value on the property based upon the use of debt obligations of the United States. Based upon your tax assessment valuation, it appears the County of Broward Revenue Department accepts that value you presented and then applies a multiplier or a millage rate against value presented based upon debt obligations of the United States to compute the tax due. I too take specific observation that there is no $ in front of values placed on your notice. Then I go on to number 2. I require that you wet ink sign and return to me the actual notice of proposed property taxes and proposed or adopted non-ad valorem assessments hereto attached. I require that you, as property appraiser, a duly authorized constitutional offer, sign the actual individual 2015 notice of proposed property taxes and proposed or adopted non-ad valorem assessments for Rubio Anthony with the following statement. I declare or certify, verify, or state that under penalties of perjury that the foregoing is true and correct property tax assessment based upon the market value of Federal Reserve notes on January 1st, 2015 for parcel number blah blah blah. Executed on this date with her signature. The verbiage is hereto attached to your 2015 notice for your convenience. When signed with wedding signature, please return original to Anthony Rubio. I believe many government forms require a person's signature attesting to the accuracy and truthful facts contained within the document, so I trust this will not be a burdensome requirement. Please address the 2 issues above within 5 business days of receipt of this correspondence. You will find enclosed 1 lawful United States dollar for valuable consideration for your service. Should you decide not to respond specifically, accurately, honestly, and completely to these matters above, I will accept your dishonor as a breach of contract confirmation that 31 USC 3125 applies, and you as a duly authorized public official are in violation of the statute of the United States. It is my desire in good faith to support and aid the United States due to a declared national state of emergency dating back to the 1930s, and I trust you can agree with the support and aid of the United States. Please note I may have further correspondence pending your response or lack of response. So what I did was I took her notice and I wrote at the bottom the under penalties of perjury statement. So this is what I get back from Mila Schwarzreich, dated September 10th. Your letter dated September 1st, 2015. Mr. Rubio, it's not even dear Mr. Rubio. This letter shall serve a response to your certified letter dated September 1st, 2015. The Broward County Property Appraiser complies with 193.011 Florida statutes in arriving at the just valuation of all property within Broward County. The millage rates are set by taxing authorities, which include school board, county commission, city commission, hospital district board, water management district, etc. The property appraiser has nothing to do with setting the millage rates. If you have, of course, this is not what I'm asking. If you have any questions regarding how the taxing authorities arrive at your millage rate, you should contact the taxing authorities. A certified copy of your trim notice is enclosed. The $1 enclosed in your letter was applied to the certification for the trim notice. Sincerely, Mila Schwarzreich, General Counsel. So, of course, you don't think I'm going to let that go, right? No. So I send it out certified again with a notice of default with opportunity to cure. So this is dated September 17, 2015. Dear Lori, first I want to thank you for a timely response dated September 10th, 2015 and received by me on September 12th, even though it was unresponsive to what I specifically required to be addressed. Second, I presume from the letterhead Lori Parrish, Broward County Property Appraiser, the letterhead, and signed by Mila as General Counsel, that Ms. Schwarzreich is your authorized representative and had your consent to respond in the manner which she did. Since it was my intent to address you personally and privately, I presume that by Ms. Schwarzreich's response that is your preference to make this a non-private matter. If I understand your oath of public office correctly, you are required to uphold the Constitution and the government of the United States, as well as the laws of the state of Florida. It is my desire too to support this idea, and this is why